Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Welcome to Your Inheritance. Welcome back to our podcast. My name is Peter Bochnewich. I've been practicing attorney for 33 years, and my practice is primarily dedicated to trust and estate litigation in Southern California. And you can visit my website at www.betrustlaw.com. Now, my practice causes my firm to be regularly in court, probate court, in trial, and in many proceedings regarding trust and estate matters, typically regarding disputes that sometimes arise between heirs, beneficiaries, siblings, brothers and sisters, stepmothers and stepchildren, and fiduciaries such as trustees in those disputes. And this podcast is designed to explore and discuss the issues that often come up in such trust and estate matters. We also do some estate planning, and we handle a lot of probate matters. And one of the things that comes up frequently when we get calls every week, sometimes every day even, about probate matters where someone does not have something covered by a trust, and they do not have something covered by what's called non-probate transfers, and they have to probate a will, or the estate must be administered intestate, which means you're proceeding as if you had no will, and then certain statutes kick in as to who gets what in the family lineage as a matter of law. But one of the primary questions that come up, and for legitimate question, is how do probate fees and attorney's fees and things of that nature get paid in your typical probate matter? And that's where we come to our topic today, understanding statutory fees in California probate matters. So we're going to dive into this topic that raises a question for many. And you may have heard of it in the context of a probate matter, if you've ever experienced one. We call them stat fees. The lawyers call them stat fees for statutory fees. But what does that actually mean? Well, let's break it down. Statutory fees are essentially the fees that the court allows by statute, by law, it's in a statute, for attorneys and personal representatives. Who's ever the executor of the estate gets the same fees as the lawyers get when it comes to statutory fees, the executor or the administrator of the estate. And these are set by statute, and they're based on the value of the estate. It is important to note that this is a system that is regulated. It's completely statutory, and it's designed to provide a clear framework so that you, the client, the prospective client, knows what the compensation is going to be out of the estate before you even go through the estate, before you go through the probate process. You know up front. And we typically lay those out in our engagement agreement. I think most attorneys would do that. In addition to statutory fees, there is a segment of, and I'm going to get to the amounts of the statutory fees in just a minute, but in addition to statutory fees, which is a percentage of the estate in certain increments of the value of the estate, there's something called extraordinary fees, and we call them in the profession XO fees. And these are for specific services that go beyond what is typically covered by statutory fees. And together, these fees create the total compensation that any law firm that you hire in the state of California may receive for their services, which is then finalized at the end of the probate proceeding. And then the lawyers have to petition the court for approval of their fees, and the court signs off on all of it. So you don't pay anything until the end of the case. Statutory fees or probate or extraordinary fees in terms of probate fees in a probate until the court approves it. And of course, you're involved in that whole process of reviewing what it is. And so are all the beneficiaries or heirs of the estate. Now let's focus on statutory fees. What are they? Well, there is a specific schedule is laid out in the California Probate Code, particularly in section 10810. And here's how it works. On the first $100,000 of the estate, the law firm and the personal representative is entitled to 4%. On the next $100,000, it's 3%. On the next $800,000, it's 2%. On the next $9 million, it's 1%, and one half of 1% on the next $15 million. For estates above $25 million, the court will determine what is reasonable. Let's just take an ordinary example. Small estate. Let's say there was a small estate that had to be probated. Kind of difficult to have to do that, and there are proceedings where you can get small estates through what's called a 13100 declaration, small estates declaration. But let's say it's a few $100,000 of an estate. Well, you take 4% of the first 100,000 is 4,000. Then the next 3% of the next 100,000 for the fees would be $3,000, and then calculate the 2% on whatever the next. Let's say there was another $200,000, so it'd be another. Let's say it was $400,000, so it'd be 2% on the next 200 of that 400, so it'd be another $4,000. Add that all together. That's 4, 3, and 4. That would be the total amount of fees that you would have for that size of a probate estate. Now, in addition to that, there would be an amount that could be allowed depending on the services required for extraordinary fees. And these are also specifically governed by statute. A lawyer can't just charge you whatever they want and call it extraordinary. The judges will review that, and they will often ask the question if someone's going outside, coloring outside the lines, and most lawyers don't do that. Sometimes there's gray areas of whether something falls strictly within the statutory fee framework or as an extraordinary fee. But the law provides pretty good guidance as to what would qualify for an extraordinary fee. If your lawyer has to help you, or his paralegal staff has to help you selling or leasing a property, that entitles the lawyer for an extraordinary fee. If your lawyer has to help you in the management or the dealing with a decedent's ongoing business, that entitles the law firm and the personal representative to an extraordinary fee, in addition to the statutory fee. It's all in addition to preparing tax returns, handling audits, or litigation relating to liabilities would quite often fall within the statutory framework and the rule of court framework for what is defined as qualifying for an extraordinary fee. Legal assistance with real property sales, securing loans to pay estate debts, litigation that benefits the estate, defending against will contests. These would all be considered extraordinary fees that if you negotiate those types of actions that would come out of the estate with your lawyer, that would be an extraordinary fee that would be calculated if the lawyer doesn't sometimes require that they would have to be paid as they go along, which in litigation is often the case. Interestingly, attorneys can work on a contingency fee basis for extraordinary legal services, providing certain conditions are met, but that generally is going to require court approval. Now, what are the rates for extraordinary fees? Extraordinary fee rates are going to be the rates that the lawyer charges, their hourly rate, whatever their regularly hourly rate is, and the regular hourly rates for their paralegals, which are typically less than a lawyer's rate. A lot of times, and we typically do this at our office, we don't have a tremendous amount of extraordinary fees at lawyers' hourly rates, because our paralegals who bill at a lot less of an hourly rate are quite competent. They must work under the supervision of an attorney. That lessens the blow of extraordinary fees when we get to real property sales in the state of California that we handle for our clients. An extraordinary fee for a lawyer will be the regular hourly rate that you negotiate, whatever their regular hourly rate is. If you agree to it, if you hire them, then if they have any extraordinary fees, that would be put in their petition along with those of their paralegal. It would all be paid out of the estate before the estate is distributed at the end of the case, along with the statutory fee calculation. In addition to that, there would be costs that would have to be paid. Typically, when we are retained to handle a probate matter, we ask for a certain amount of money up front. It's usually not a great amount of money, but we're allowed to ask for a certain amount of money up front to pay for the hard costs of getting through the probate. We must wait till the end of the case to get paid our statutory fees. We must wait till the end of the case to be paid the extraordinary fees. For all the extraordinary work that we do, we must wait to the end of the case for that in a probate structured manner that is subject to the petition process before the probate court. What doesn't count as fees would be those types of things like your filing fee for filing the probate matter. That's a governmental fee that we don't mark up or anything like that, but it's and lawyers just put that on they include that in the petition at the end of the case to say what their costs were if they need to be reimbursed for some reason at the end of the case. But you are allowed to ask for a certain amount of that up front to get the case going. There are publication fees in newspapers where you have to publish the fact that the estate is being probated and so on and so forth. We get that money up front. Again, that's expended 100%. There's no markup. The lawyers don't do that. And certain other fees. At some point, there will be a fee for the probate referee that reviews inventory and appraisals, all these processes that are very rigorously watched by the court at certain junctures of the probate proceeding. You file your petition for probate, you get your letters testamentary. There's all these things that go on. Then you have so many days where you have to get an inventory and appraisal of the estate's assets on file. Maybe you don't get it in on time because of various complications in the estate, but the court keeps a very watchful eye on that. And the probate examiners of the individual probate departments in Southern California, typically very good. In Riverside County, we have probably one of the best probate departments that there is in all of California. And we deal with probate departments throughout Southern California, and the people are very diligent and they're very good and they really know what they're doing. And they're taskmasters for the lawyers to make sure that they're doing it right. And they give them notes that they post online to make sure that they're doing them right. So it's a very orderly process, and the fee structure is very predictable. I think statutory fees are very favorable to families and to clients. They're not onerous at all, to tell you the truth. Extraordinary fees could get to be higher, but again, these must be approved by the court. Now, I've never had in my time someone say that an extraordinary fee, I can't even remember when an extraordinary fee that I asked for wasn't approved, but there are occasions when you're in court and a judge might ask, well, why couldn't that have been done within the statutory framework? I respectfully submit that we don't get that question, but sometimes the courts will ask that of folks, and then the lawyer might have to give an explanation as to why in a particular case, something that might look like it would be covered by a statutory fee really is entitled to extraordinary compensation, and it's very infrequent that happens. The rules are pretty clear about what you can get and what you can ask for, and most attorneys, color within the lines and do a good job at that. As I mentioned, we try to make use of our paralegal staff as much as we can at the lower hourly rates to do the legwork that's necessary for these extraordinary activities, and that really helps keep the extraordinary fee aspect of the probate, the fee impact to the probate estate low. So those are some of the rules that are involved in statutory fees and in extraordinary fees. They're not all of the rules, they're not all of the nuances, but that hopefully will give you some background on these types of questions. Like I said, it's a question, it's the first question that's often off the tip of people's tongues when they ask, how does it work? How does the probate process work, and how is our estate going to be impacted by the work that you've got to do? Personally, I think the fee structure is reasonable. It's actually fairly modest in some respects. In smaller states, it kind of creates a little bit of a question as to how, making it economical to do the work, but there are ways to handle that as well. And then there's, of course, a cap on larger estates where it's there's the percentage gets lower as the value of the estate goes up, so that it's actually quite reasonable controls on the compensation for both attorneys and also personal representatives, whether that personal representative is an executor under a will, or whether that personal representative is an administrator of an intestate estate, or possibly an administrator, not a named executor, but as an administrator with the will annexed because no one named in the will could serve. I hope this helps with understanding basically the statutory fee structure in the state of California, as well as the some information about extraordinary fees. If you just Googled California Probate Code section 10811, you'd probably find a way to a link to a site that will lay out the statutory fee schedule right out there for you. And I hope this helps. That concludes my bit for today. And thank you for tuning in to Your Inheritance, and we'll see you next time. Thank you.
You've been tuning in to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. If you're being sued over an estate, or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.